Hello everyone, I'm Leah from TYFU and welcome to our TYFU webinar about unfair dismissal and redundancy claims. We're very fortunate today to have Layla Cachalia, an expert in employment law from the highly respected Maurice Blackburn Lawyers, joining us today to guide us through this really important topic. Layla is going to walk us through the process, key signs to look out for if you believe you have a case, and the critical timeframes involved for taking action. We're so grateful to have Layla share her expertise with TYFU, and there will be some time at the end for questions. So without further ado, I'll hand over to Layla and I'll let you begin. Thanks, Layla.
Great. Thanks, Leah. Really appreciate the opportunity to chat about unfair dismissals. I've prepared a short slideshow, so I'll get Lee to send you those slides after today as well. That might be helpful for everyone.
Thank you.
So I'll just start going through that now. All right. Just confirming everyone can see my screen at the moment.
Yes.
Okay, perfect. So we have a lot of clients come to us who have experienced, termination at work, and I think it's very stressful for them. So I thought putting together some points about what to look out for in those circumstances would be quite helpful to try and navigate those difficult situations. So I'll go through a couple of slides today, just setting out some high-level advice about what to look for, as Leah has explained. So if you want to lodge an unfair dismissal claim, these are done so under the Fair Work Act if you're a private sector employee, or under the Industrial Relations Act for anyone who works in the public service or for local government employees. There are some strict requirements and criteria for being able to bring a claim, and you need to be really clear that you meet those criteria. Otherwise, the relevant commission might be minded to not let it proceed. So the first is a minimum period of employment. So that has to be 6 months prior to dismissal, or if you are employed by a small business, it's 12 months. A small business is a business which has 15 or less full-time equivalent employees. There's also a high income threshold, which gets increased each year. It's currently 175K. So you can't earn above that. But if you do, and you're covered by an award or an enterprise agreement, which is registered with the Fair Work Commission, you are still able to bring an unfair dismissal claim. There are some individuals who can't, who are independent contractors, a casual employee, although there are some exclusions I'll speak about shortly, or if you're engaged for a specific period or task. All right. So claims must be made within 21 days after the dismissal takes effect. This is a very strict deadline for the commission, which I'll discuss shortly. And it's from the day it takes effect. So not the day that you were notified about it, but from your last working day or your last proposed working day. You are not able to bring a claim whilst you're still in employment. It has to be after that fact. So under the Fair Work Act, which I'll be dealing with mostly today, a person has been unfairly dismissed if the commission is satisfied that they have been dismissed, the dismissal was harsh, unjust, or unreasonable, not consistent with the Small Business Dismissal Code, and was not a case of genuine redundancy. Under the Industrial Relations Act, the criteria is similar, and it looks at those criteria of harshness, unjustness, and unreasonableness. What you need to be really aware of are these jurisdictional hurdles. So if you fail to meet any of the criteria, you're essentially stopped from bringing a claim, or your employer may raise these jurisdictional objections, and your claim may not be able to proceed. So the most common ones we see, out of time filing. As I said, the commission is very strict, and they take a very hard line approach, and generally in our experience don't allow late filing. As lawyers, we tend to try and lodge claims before the final day just to make sure we're not close to the edge, but it's something to really be aware of in terms of that deadline. The failure to meet the minimum employment period I just set out, in respect of casuals, if they're unable to demonstrate a regular and systematic employment in those preceding months. With casual employees, you may be eligible for dismissal, because I understand lots of people do work casually. The work does not have to be frequent or constant. The threshold is that it will have to be a repetitive pattern of work with an expectation for that to continue. In terms of the high income threshold, as discussed, it's currently 175K. What earnings constitute are things that include your base salary. For example, if you have a work vehicle or a petrol allowance or a work phone or something to that effect. So those all need to be considered if you're a bit close to the edge in terms of the 175K, sorry. Things that are not generally included will be things like commissions or bonuses or statutory superannuation contributions. So in any employment contract will have to be looked at quite closely to determine what your earnings are, and there can be some ambiguity as to what does constitute earnings for an individual. A genuine dismissal is a genuine redundancy. I'll discuss that in the next slide. Dismissal being consistent with the Small Business Fair Dismissal Code. So under that code, a small business employer can only dismiss an employee without warning if it's for reason of serious misconduct, which is an incredibly high threshold, and include things like fraud or criminal conduct. The employee was not dismissed. So this is really important. It cannot be a resignation. You have to be terminated at the employer's initiative. We often get clients coming to us asserting that they've been constructively dismissed or as a heat of the moment resignation. It's a very difficult argument to assert, and it's very rarely accepted by the Fair Work Commission. So just something to be aware of. If you think the writing's on the wall and you wish to file a claim, if you think your dismissal is unfair, I would avoid resigning in those circumstances if you think you have a good case, because it's very difficult to try and argue that after the fact. Another evolving area of law is when fixed term contracts come to an end and whether the non-renewal of a fixed term contract is in fact a dismissal. And in some cases, and some of the case law says that it can constitute a dismissal. It just really depends on the circumstances at the time. Other case law has said that it comes to an end by way of the effluxion of time and cannot constitute a dismissal. But as I said, it's an evolving area of the law, so it's something to also consider. On my next slide, talk through the elements of an unfair dismissal claim. So Section 387 of the Fair Work Act sets out the elements of an unfair dismissal claim and what the Commission will consider and take into account when assessing whether they are satisfied that a dismissal was harsh, unjust, or unreasonable. So there are several factors. The first they will look at is, was there a valid reason for dismissal? For example, did the employee engage in misconduct? Were they underperforming? More recently, there's been an amendment to the Fair Work Act, which includes sexual harassment, if established, will constitute a valid reason for dismissal. They'll also look at whether an employee was afforded procedural fairness. So that is an opportunity to respond to allegations of misconduct in circumstances of underperformance, whether they've been put on a performance plan, whether those conversations were held with them, whether they've been given a real and genuine attempt to improve their performance, whether they've been afforded the ability to bring a support person in any disciplinary meetings, whether disciplinary action has taken place in circumstances where an employee was on sick leave or those kinds of generally procedurally fair or unfair from a practical point of view, those kinds of elements will be taken into account. In terms of harshness, the Fair Work Commission will look at things like the financial impact on an employee in considering harshness, and will also have regard to things like their age, if they're close to retirement and how difficult it may be to find further employment, their length of service, if they're a long-serving and loyal employee. The dismissal can also be found to be more harsh. In terms of redundancies, in the case of a non-genuine redundancy, a dismissal may be found to be unfair. A genuine redundancy is when an individual's job is no longer required to be performed by anyone for operational reasons. So if you're terminated and your friend gets your the responsibilities of your role, that won't be considered a genuine redundancy. So they have to make it very clear that it's not required by the organisation. That's the first step. If you're covered by an EA or an award, there's also a requirement on the employer to comply with consultation obligations. So that means consulting with employees as to workplace changes, asking for their feedback, those kinds of things. It's not simply a tick a box exercise, and it must be meaningful. Consultation can't simply be a letter to employees with no practical effect or impact of their feedback. And thirdly, an employer is required to consider any reasonable opportunities for deployment within the company or any associated entity of the employer. Often employers will ask for feedback as to potential roles. And if they have not meaningfully considered those individuals for roles where they're qualified and keen and willing to work, that could be a sign of something more sinister going on. And if these criteria are not fulfilled, it may be the case that it is a non-genuine redundancy, and this can be pursued through the unfair dismissal jurisdiction. Under the Industrial Relations Act, these kinds of considerations are broadly the same. There are some differences in terms of the case law and what the Commission will look at, but generally the impact of procedural fairness and valid reasons is similar across the jurisdictions. And what I might just run through quickly is the process before I get to remedies. So in filing an unfair dismissal claim, it's a voluntary process for the employer. Once you've filed a claim, the Commission will set it down for what's called a conciliation. This is via telephone. Generally, an employer will have a representative there, such as HR, or they might have a lawyer. Employees can represent themselves. They often choose to have representation by a union member or a lawyer or a support person. And during that conciliation, it's basically a negotiation between the parties. So unfortunately, there's no kind of judge who makes a decision about these criteria that I've just set out, but the parties negotiate to it in an attempt to reach a resolution before it's kind of escalated within the Commission. If it doesn't settle and the parties aren't able to reach an agreement, what happens is that it will be set down for what's called an arbitration, which is basically a full court hearing in the Commission. It's not a court, but just to get the idea of it. So evidence will need to be filed, and it's quite a formal process. And a commissioner will then make a ruling as to whether they believe the dismissal is unfair and make an order for compensation. So in terms of remedies, the primary remedy in an unfair dismissal is reinstatement. And that'll be to reappoint the person to the position in which they were previously employed, or a position on terms and conditions no less favourable to those that they were on before. Or it can be within an associated entity, and there will be an order to maintain continuity of service and back pay. Reinstatement is rarely awarded. It is awarded in some circumstances, but it's difficult to achieve that. Just because often the relationship between an employee and employer would have also broken down, and the Commission will have regard to that. Compensation is a more commonly awarded remedy. The most that you can be awarded is 26 weeks of pay, or half the high income threshold if you're one of the high income earners who's covered by an award or an EA. This is generally awarded in the most egregious circumstances of dismissals, and the Commission will make a reduction in any compensation if there's no financial loss that has been suffered by the employee, or the dismissal was for misconduct, but there were procedural issues with how the employer conducted themselves and the disciplinary process. At the conciliation stage, the Fair Work Commission releases statistics and has recently released some to say that 5 to 7 weeks' salary is generally what matters settle for, which is not a huge amount of compensation. So, employees do need to weigh up the risks associated with that, and may need to push a little further. So in terms of unfair dismissals generally, that's the general framework. And I'm happy to take any questions anyone might have regarding those elements and the remedies in the process.
Thank you, Layla. That was so comprehensive. To see if there are any questions right now. Doesn't seem to be any questions.
That's all right.
So yeah, I'll just say thank you so much, Layla, for sharing all of your expertise with us. It's been incredibly informative and a great starting point for anybody who is thinking about taking this kind of action. And if anybody does have further questions or wants more personalised advice, please feel free to reach out to Layla and the team at Maurice Blackburn Lawyers. You can contact them on the phone number on their website, and I'll also share that with you. Sorry, Layla, we just had a last minute question from Simon as we're wrapping up. How does the cost work to taking legal action?
In terms of the cost for the conciliation stage, generally we have a consultation with a client and we'll assess the amount of work that's required and provide clients with a cost agreement. So it will depend on your circumstances and the work involved in preparing the claim and attending.
Okay, great. Thank you.
Yeah. No
if you did want further information on the costs involved or anything else, you can definitely get in touch with Layla. Thank you so much for your expertise and your time, Layla. Appreciate it.
No worries. Thanks, Leah. Appreciate it. Speak soon.
Bye-bye.